Hi, everyone. This is Tom Sullivan from Philadelphia, Strick's office in Philadelphia, and I'm here with Andy Trask, here virtually at least. Andy's in San Francisco, and this is the third installment of Class Action Quick Hits. And today we have a very exciting, really interesting case to talk about. This is a recently decided case. A case decided April 22nd, and the name of the case is In Re Lamictal Direct Purchaser Antitrust Litigation. And this has decided by the Third Circuit, so very important case for practitioners in the Third Circuit. And we're going to talk about the significant implications of this one in a bit, but it's important to lay the groundwork for this a little bit. This case is a class action case by direct purchasers of a brand drug manufactured by GSK and a competing generic drug that was going to be manufactured by Teva. The origins of this case arise out of patent litigation between GSK and Teva several years ago. As often happens in this industry, the brand manufacturer here, GSK, the manufacturer of Lamictal, sued Teva, the generic manufacturer of Lamotrigine. And I don't know if I'm pronouncing that right, but that's my best effort. And GSK was sued Teva for patent infringement. In the patent infringement case, Teva received a somewhat favorable ruling, and that led to a settlement shortly thereafter between the two companies. As part of that settlement, and often the case in this industry when there is patent litigation between the brand and the generic, the companies entered into an agreement called a reverse settlement agreement. And the terms of this agreement are important for understanding the implications of the later class action brought by the direct purchasers here. Specifically, what happened as part of the settlement agreement is that GSK agreed that Teva could bring the generic product to market 6 months earlier than Teva otherwise could have if GSK had won the suit, but later than it would have if Teva had won the litigation. In turn, GSK agreed as part of that settlement not to launch its own generic Lamictal, what is sometimes referred to as the authorized generic. So in other words, once Teva hit the market with their generic, GSK could have launched its own generic product, the authorized generic, to compete against it. This strategy, which again is common in this space, fosters antitrust concerns and often prompts the attention of enterprising class action lawyers. Here, the direct purchasers were companies that purchased the brand Lamictal product, as well as purchasers of the Lamotrigine product, brought suit on the theory that the settlement, the reverse settlement agreement here, violated the antitrust laws. The theory that but for this reverse payment, Teva would have launched Lamotrigine sooner and GSK would have launched an authorized generic at the same time, that would have resulted in competition between them, and that would have led to lower prices for everybody. So on the theory of the direct purchasers, they paid more than they would have but for that reverse payment, that reverse settlement agreement. Now, one final key fact in this case that surrounds the settlement is that SK had what was described by the court as a contracting strategy under which they were going to sell Lamictal to pharmacies at significant discounts and rebates to discourage them from moving from the brand to the generic product. Now, the significant fact about this is that Teva found out about it. And it was critical to the defense of both GSK and Teva against these direct purchasers that Teva had learned of this strategy before it began selling Lamitrigine. So, in other words, Teva would have been able to respond in the market to this action by GSK. So they argued, in fact, that direct purchasers never paid more for the products than they would have. In other words, they argued that they weren't injured. Now, Andy, do you want to cover some of the critical aspects of the court's holding as it considered this issue for the class action analysis of the elements of Rule 23?
Absolutely, Tom. Thanks. It's the primary thing that the primary thing that the Third Circuit did here was it reaffirmed the standard for certification in the Third Circuit. That requires a rigorous analysis of the facts and the law in dispute, an actual resolution of factual disputes, which is something that some circuits are rigorous about and others less so, and the Third Circuit's preponderance of the evidence standard. That is, in order to actually get a class certified, you have to have more evidence in favor of certification than evidence against certification. And so that's something that often district courts don't pay as much attention to as they should. Usually in the Third Circuit they do, and in the Second Circuit, because those are the two appellate circuits with an articulated standard. So as a result, actually, why don't we give it back to you, Tom, to talk about Lamictal in a nutshell in terms of what the court wound up ruling on the antitrust side.
Sure. So the direct purchaser's theory of liability here is that on average, and this is a premise, an important premise of their theory, is that on average, the price of the generic drug is lower when there are two generics rather than just one. And here, the plaintiffs presented evidence, expert evidence, that relied on average hypothetical prices. But significantly, the plaintiff's expert did not, his analysis did not take into account GSK's contracting strategy and the fact that, as we mentioned earlier, Teva had an understanding of that. So it did not take account of the individual negotiations that were going on in the background, but made assumptions that did not necessarily reflect the real world. So defendants were able to argue in their own expert presentations and their own expert reports that some direct purchasers, in fact, had never paid more. And because of this GSK contracting strategy to provide pharmacies with lower prices for the brand product. And therefore, Teva also did not uniformly respond to GSK's pricing strategy. There was competition going on in the market around the fact that there was going to be not only a generic, but potentially an authorized generic.
Right. So what are the takeaways from this particular case? From a legal standpoint, there are three key holdings that you want to pay attention to. The first of these is that you can't use averages in certifying a class outside of, at this point, the Fair Labor Standards Act, which is the key to many employment class actions. The court here specifically ruled that the district court abused its discretion when it assumed without a rigorous analysis that the experts' averages were acceptable. In particular, average hypothetical price did not account for these individual negotiations that Tom's alluded to, or to the effect of GSK's overall contracting strategy with each of the purchasers it was dealing with. So there was no way to tell whether or not individual buyers were harmed. You were only looking at whether or not, on average, the average purchaser might be. And remember, average doesn't even mean median. If you had one or two purchasers that were harmed to a great degree, that could make up for a majority of purchasers who weren't harmed at all. So averages in that sense are incredibly deceptive, and the court recognized that. Now, why do we make this exception for the FLSA since it got brought up in the court and since we brought it up here? The reason is because the statute specifically allows for the use of average evidence when you don't have better evidence than that. And the Supreme Court relied on that when it affirmed the certification of a Fair Labor Standards Act class action in Buapakeo versus Tyson Foods back in 2016. So far, however, as a number of commentators at the time predicted, that ruling that you can use averages under the FLSA has been confined to labor class actions and really hasn't made it out to antitrust class actions or consumer class actions or even securities class actions. The second big takeaway in this case would be that in this particular case, you have a good idea of what a failure of rigorous analysis looks like. Remember, this is one of the key holdings that the court reaffirmed, was that you need a rigorous analysis. And in this case, it's possible that averages might have been acceptable even without a statutory authorization if one of three things had been true. If the market had not been characterized by individual negotiation, but in fact had been the kind of market where you set a price and everybody meets it, that might be a time when you could use the average wholesale price. If the defendants have preemptively lowered their pricing in response to their contracting strategy, that might have been a way in which you could have brought in these average prices instead of having to look at individualized negotiations. And if GSK really would have acted differently without the settlement agreement, that's another place where you might have really looked where it might have been appropriate to have brought in these average prices. All of these questions were hotly contested by the parties. In other words, the plaintiffs asserted, and to the extent they could, they tried to prove that each of these questions would be resolved in their favor. And the defendants came back and offered serious evidence that, in fact, individual negotiations were a big deal in the market, that they were not preemptively lowering their prices, and that they would not have acted any differently under other circumstances. The court, surprisingly, didn't decide any of these questions, even though any one of these could have been central to the certification inquiry. Frequently, I think, courts get bogged down by these kinds of questions and decide it's better to punt than to actually resolve these things. There are several courts at this point. The Third Circuit had ruled before. The Second Circuit and the Ninth Circuit have actually both ruled that you need to resolve contested factual issues at class certification if they're going to matter to whether or not you can try things on a class-wide basis. The district court here didn't want to do that. It sort of stepped back from it and made some assumptions, and that's the reason that it got reversed. That, as it turns out, is an abuse of discretion. Now, the final thing that we want to talk about here in terms of takeaways is the fact that when we're looking at various class actions, injury, which is always a fact that you have to prove to demonstrate liability, is not necessarily the same as damages. Why is this important? This is important because most courts and most appellate circuits have drawn a distinction between whether or not individualized issues predominate at the liability stage and whether or not they predominate at the damages stage. And most courts have said that if all you're doing are routine damages calculations according to a formula, there's no reason why that has to be there's no reason that means that you would have to not have a class. You could have a class where there is, at the end, a brief 2 or 3 week period where you bring in an expert specifically to make damages calculations. However, if the damages will frequently be zero or negative, in other words, if the damages are such that what you're really talking about is whether anybody was injured in the first place, then it's not a damages inquiry. It's actually an inquiry into liability. And that's the kind of inquiry that you're supposed to be able to demonstrate with complete class-wide proof. So in this case, the court recognized, the Third Circuit did, that they have consistently distinguished, try saying that 5 times fast, or even once in my case, consistently distinguished injury from damages. In other words, injury is part of the liability inquiry, damages are part of the damage inquiry. And in this case, getting into whether or not that average pricing was relevant, you were getting into whether or not you could show that certain people had been harmed in the first place. That's the kind of inquiry that you can't put off and you can't punt until later. There are several other implications that involve what litigation will look like going forward in both antitrust and class actions as a result of this ruling, and Tom is going to tell you about those.
Sure. So, Andy, I think one key takeaway of this, especially for practitioners in the Third Circuit, is that, as you mentioned, it reaffirms some important instruction from the Third Circuit about rigorous analysis in this circuit, reaffirms important cases like In re hydrogen peroxide and Marcus versus BMW, in which the court emphasized the rigorous analysis standard. And as you mentioned, encouraged the court to rule and to really dig into these issues. I think if you read the Third Circuit opinion pretty carefully, in some respects, it's basically saying that the court didn't pay sufficient attention to some of the information in the expert reports and made assumptions that weren't justified. I think, overall, this case probably stands for the proposition that, as class action practitioners, you really need to be focused on developing a comprehensive record and making sure that you present a comprehensive picture to the district court, and if nothing else, preserve that, for appeal on 23F or down the line or trial, whatever the case is, because there are important issues factual issues that end up mattering significantly to the Rule 23 analysis. One other issue, Andy, we don't have this set up in our implication slide here, but I know this is an issue you're interested in, and you mentioned, I think, the Ninth Circuit and the First Circuit cases, and there are cases like Asacol and In Re Consolidated Freight that are touching on issues that are similar to what's going on in this case. And I wondered if maybe you want to say, just spend a minute on that, because I think we've got an issue brewing here in some of the circuit courts about, injury in the context of the predominance analysis, and when it is that it may or may not be, when it is that predominance may or may not be satisfied, depending on how many putative class members are actually injured.
Sure thing. That's a very good question, and it's raised and not directly addressed in this opinion, in the sense that there appear to have been class members who might not have been harmed at all. But the court, because it didn't have a well-developed factual record in front of it, didn't make any estimation as to how many of those absent class members might have been uninjured class actions. By contrast, in the last year, there have been at least 2 other cases that we know of at the circuit court level, Asacol in the First Circuit and Freight Surcharge in the DC Circuit, that have both taken classes where it was known and admitted by the plaintiffs that a significant percentage, a sizable minority of class members had not been harmed for various reasons. In Asacol, it was because there were a certain number, I believe it was somewhere around 12.5% of the absent class members, who had specifically said that they would not have switched their medication decisions, regardless of whether or not Asacol was marketed as a generic or as a specific, or a specifically branded medicine. And that meant that they would not have changed their purchasing decisions and therefore had not overpaid for anything. In Freight Surcharge, I believe it was at least 10% was the estimate. And so both of those courts together have come up with an estimate that if you have more than 10% of your class that you know to be uninjured, that raises predominance issues at the liability level. And therefore, because you really can't give 10% of the class a windfall, that's just against due process. So that requires you to ask who's injured and who's not. And once you've started making that inquiry, the individualized inquiries in the case just wind up overwhelming any common issues that we might have had. So right now, we've actually got a holding in at least 2 circuits that says that a specific percentage, likely larger than 10% of the class, if that is uninjured, then you're going to run into trouble here. It's interesting because the Third Circuit actually, in a settlement context, at one point had spaced down a significant number of uninjured class members in DB versus Sullivan, which was decided back in, I believe, the early teens. But because it was a settlement class action, the Third Circuit specifically held they didn't have to worry about that question because the defendant had decided it was worth paying for all of that just to have finality. This is the Third Circuit, I think, beginning to edge up to reevaluating that. They didn't have the evidence here, but you can see that they're requiring the evidence going forward, and they're requiring it in part because they think there will be an inquiry, which is a good reason to assume that if the Third Circuit's faced with the actual question, they'll probably rule in the same way as the First and the DC Circuits did.
That's great, Andy. And I think I said consolidated freight. I meant the surcharge case. In any event, I think this is a brewing issue and certainly an issue in the background here as the district court considers this case further after the remand. But just one to watch in the Third Circuit and certainly outside of it for the reasons that Andy was talking about. And that wraps up our discussion about in re Lamictal.
Thanks for taking the time with us, and we'll see you next time.
Thank you.